When advisors and organizations discuss student speech rights, they often talk about a select group of Supreme Court cases. In this chapter, we'll examine how cases such as Tinker, Bethel, Hazelwood, Morse, and Mahanoy have shaped our understanding of students' right to free speech at school. When Tinker versus Des Moines Independent School District often comes up in conversation first, it isn't the first time students' First Amendment rights came up at school. For instance, West Virginia State Board of Education v. Barnett, in which the court ruled students cannot be forced to pledge allegiance to the flag, predates Tinker by more than 25 years. But Tinker is significant in determining when school officials may intervene in students' expressive actions, as well as giving us a pretty famous quote. In December 1965, a group of students and their families decided to protest the Vietnam War during the upcoming holiday season by wearing black armbands. Des Moines school principals learned about the plan and preemptively decided to ban armbands on campus. Students who refused to remove their armband would be suspended until they agreed to return to campus without it. Mary Beth and John Tinker and their friend Christopher Eckhart all received suspensions until after their planned protest. In a 7-2 decision, the Supreme Court determined the ban and suspensions suppressed the students' First Amendment speech rights. Justice Abe Fortas wrote for the majority, "It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." As with the First Amendment as a whole, the court did not give students absolute free rein on campus. Rather, the ruling established a standard school officials needed to follow in limiting student speech. Expression that would substantially disrupt the school day or infringes on others' rights is not allowed under the Tinker standard. Fortas stressed the potential for disruption is not enough. Administrators must have significant evidence the speech would disrupt school operations. We'll actually see the substantial disruption standard applied a bit later. Almost 2 decades after the Tinker ruling, cases in 1986 and 1988 shaped student speech even further. The first, Bethel School District No. 403 versus Frazier, addresses vulgar and profane language. At a student assembly, Matthew Frazier delivered a speech nominating one of his classmates to an elected office. The speech contained multiple double entendres, such as, "I know a man who is firm. He's firm in his pants, he's firm in his shirt, his character is firm, but most of all, his belief in you, the students of Bethel, is firm." And, "Jeff is a man who will go to the very end, even the climax, for each and every one of you." Prior to giving the speech, teachers warned Frazier it wasn't a good idea and there may be consequences if he chose to deliver it as planned. During the speech, students hooted and hollered and pantomimed sexual actions, according to several teachers in attendance. The principal notified Frazier he'd violated a school rule stating, "Conduct which materially and substantially interferes with the educational process is prohibited, including the use of obscene, profane language or gestures." As a result, Frazier received a 3-day suspension and was removed from a list of potential graduation speakers. In the ruling, the Supreme Court justices noted that while schools serve as a forum for controversial and unpopular opinions, officials also have an interest in teaching students proper decorum. Many of the audience members were high school freshmen and, in the words of Justice Warren Burger, on the threshold of awareness of human sexuality. Burger also wrote, "By glorifying male sexuality and in its verbal content, the speech was acutely insulting to teenage girl students." 2 years later, the Supreme Court dealt a blow to student press rights in the Hazelwood School District v. Kuhlmeyer ruling. Former high school journalists argued their rights were violated when the principal removed 2 pages from the school newspaper. While the pages contained content the principal did not object to, the administrator felt an article on teen pregnancy was too mature for the younger members of the student body, and an article on how divorce affected a student did not fairly give the parents the right to respond. In a 5-3 decision, the court gave administrators the right to restrict content if they had a reasonable educational purpose to do so. Some important things to note about the Hazelwood newspaper that influenced the court's decision. First, the newspaper was offered as a course for credit with a faculty advisor. Prior review, a process in which the principal approved content before the paper went to print, was an established process at the school. And finally, the faculty advisor practiced extensive control over the publication, according to the court, in determining the editors, assigning stories and deadlines, and even selecting the letters to the editor printed in each issue. This meant the paper was not a public forum for student expression. Check out the vocabulary section of this chapter to learn about different types of forums. The court used Bethel in justifying its Hazelwood decision. The former case established a right to limit speech that goes against the educational mission of the school. Hazelwood took this further by applying it to non-vulgar or non-profane speech. Our final two cases came during the Roberts Court. Because the Olympic Torches route passed by the school, students from Juneau Douglas High School were permitted out of class to watch. Under the supervision of school personnel, students were able to stand both on and off campus to see the event. Joseph Frederick and some of his friends held up a sign declaring "Bong hits for Jesus" as the torch and camera crews passed by. Frederick consequently received a 10-day suspension for violating a district policy prohibiting language that advocated the use of substances that are illegal to minors. While Frederick was not on campus grounds, the principal said his participation in a school-sponsored event made him subject to district policy. In his majority opinion, Chief Justice Roberts agreed with the principal. Frederick wasn't only at a school-sponsored event, he even pointed the banner at the school and was visible from school property. In addition, Frederick, by his own admission, wasn't making a political point. It was meant to attract attention. Perhaps a poster discussing the criminalization of marijuana would have had more merit in the eyes of the court. A nonsensical phrase certainly didn't. For years, journalism advisors teaching students about the First Amendment would caution students it was unclear in the age of the internet where the boundary between school and home stood. In 2021, the Supreme Court finally gave us a little guidance in Mahanoy Area School District, VBL. After she didn't make the varsity cheer squad, BL took to Snapchat to voice her frustrations. The post said, and in case you're at school, here's the public radio version: F school, F softball, F cheer, F everything. It accompanied a photo of BL and her friend giving the middle finger. Notably, BL and her friend were at a convenience store on the weekend at the time she posted the diatribe. As teenagers sometimes do, one captured the Snapchat story before it disappeared and shared it with others, including the cheerleading coach's daughter. Several cheerleaders also brought the message to the coach's attention because they were upset. Because the post used profanity and was related to a school-related activity, the school decided to suspend BL from her spot on the junior varsity squad for the following season. In a 7-2 decision, the court sided with BL. In the majority opinion, Justice Samuel Breyer said the school was not acting in loco parentis. The time and location she made the post placed her firmly outside the school's jurisdiction. In addition, there was no substantial disruption. Remember Tinker? Students discussed the post in an algebra class for a few periods, but otherwise the school operated as usual. And Breyer wrote, "The schools have a place in teaching students the saying, 'I disapprove of what you say, but I will defend to your death your right to say it.'"